Tom is a graduate of Odessa Permian High School, earned a chemical engineering degree from Texas A&M University, an MBA from Harvard Business School, and a Juris Doctor from the University of Houston Law Center. Since retirement from his career in information technology with ExxonMobil, he has spent full time pushing important liberty issues at the last 3 Texas legislative sessions. After the 2019 Texas legislative session, Tom created the Boot Bonham PAC and the lively Boot Bonham Facebook group to ensure that Speaker Dennis Bonham would not be elected to the Texas legislature again. Tom is a member of the John Birch Society. He is the founder and leader of Texas Constitutional Enforcement. This group has pivoted to focus on how to stop Texas elected officials from violating the Texas Constitution and Bill of Rights.
Amen.
Tom has spent his life working for limited government in various ways. Most recently, he filed an amicus brief for Texas Constitutional Enforcement in the Texas Supreme Court for Shelley Luther in a writ of habeas corpus challenge, and led the Texas constitutional enforcement effort to put the lockdowns never again and the addition of prohibition of mandatory vaccination in the Republican Party of Texas platform. Please welcome Tom Glass.
Thank you. We certainly do need a new one. I'm not sure I'm the guy. That's great. Okay, today I'm going to talk about the constitutional issues related to the COVID fiasco we've experienced this year. And so I guess I'll just jump into it. I want to talk mainly about lockdowns, about contact tracing, and mandatory vaccination. With lockdowns, I'll kind of also mention mask mandates as we go. And I try to update a little bit of what these slides have, which I made several months ago. So, okay, let's go ahead and jump into it. First, the thing is, Thomas Sowell, fantastic guy, said Constitution can't protect us unless we protect the Constitution, and that's why I created the group I do. And we all have to take action. It's the Constitution, not a self-enforcing document. And when you think about it, we live under 2 constitutions, the United States Constitution and the Texas Constitution. And I've been focusing of late on the Texas Constitution primarily because it's a restraint on Texas officials. Sure, the federal government, although its primary responsibility is to restrict federal officials, with the 14th Amendment, the federal government also restricts Texas officials as well. But the Texas precedents and the Texas constitutional provisions that we have for liberty actually constrain Texas officials more than the federal Constitution does. And if you're looking to restrain your Texas officials to limited government and constitutional principles, you want to use the Texas constitutional provisions, and you want to use the Texas judiciary, who are more friendly to liberty as a rule than the federal judiciary is. And even there's precedents out there from the United States Supreme Court that defer to the Texas Supreme Court when you interpret the Texas Constitution. So that's where I'm going to be focusing most of my firepower today. There's 4 main constitutional arguments about the types of actions that have been going on lately by the governor and the county judges and mayors. The first one is separation of powers, and we'll talk about each one of these. The next one is due course of law. And then there's the definition and application of natural rights that essentially the Bill of Rights are trying to protect. And we'll talk a little bit about that. And then there's the equal protection arguments. Are you an essential worker? Okay. All right, separation of powers. First, you start off the wonderful provision in Texas Constitution. It's Article 2. There's only one section in it, and this is all of it. I'm not going to read it to you, but the bottom line is the legislator is supposed to create law and legislate. And the governor is supposed to implement that, and the judiciary is supposed to rule on the constitutional issues and on the statutes that the legislature does. And essentially what we've had from the governor and from our county judges is legislation from the governor's mansion and from the county courthouse is what we've had, which is a clear violation of the separation of powers provision in our Constitution. So let's, and in fact, I think there's a very clear way to express that, and this is the meme I created for this, but I put out on social media. Executive orders are not law. They're just not. Okay, that's not what I want to do. Let me just talk briefly about what an executive order is. An executive order is designed so that an executive can tell his employees how to consistently implement policy. It's how to abide by the Constitution, how to implement the law. But the clear sign that an executive order is illegitimate is when it tries to put prohibitions and punishments on the citizenry. That's clearly a wrong implementation of an executive order. It's an illegitimate executive order, and that is what we're living under right now. And I'll get into a little bit more of that. I don't know if you've heard Father Guido Sarducci's from Saturday Night Live back in the 70s. He had the 5-minute university, and he talked about at the end having the 2-minute law school. Essentially, his idea is that he will just teach you everything you'll remember 5 or 10 years after you get out, and that's as good as spending all that other money. He could do it a lot cheaper. And so part of my 2-minute university lecture is something I learned from my professor Ragazzo at University of Houston Law School. And he said, put your beady little eyes on the document. It's the most important lesson I learned in law school, probably. Don't accept what, quote, experts say something says. Go read it. Go read it. I guess I didn't really need to be taught this in law school because I learned it at First Baptist Church, Odessa. You go read the foundational document that you have, and you use your own judgment and understanding to figure it out. And I take that same approach that I took to my Bible when I was a young man, and I take it to the Constitution, and I encourage every one of you to do the same. Now, to my Catholic friends, I will say this. Even if you believe that an expert should be the person that interprets the foundational document to you, I will just tell you the Supreme Court is not the Pope, and they are not divinely inspired. So, okay. This is a busy picture of one of the many. I have lost count of how many executive orders the governor's put out through this, but I highlighted and I blew it up here. This is putting my beady little eyes on the document. I put my beady little eyes not only on the executive order that the governor did, but I also put it onto the statute that he was trying to do. Well, of course, in his executive orders, the governor claimed that he has the authority to do this under a thing called the Texas Disaster Act, which was created in 1975. And he claims that he has the power to do executive orders. In fact, this is what he said in his executive order. Let's see if we can point at it. He says, under Section 418.173, Chapter 418 is the Texas Disaster Act in the Government Code. Failure to comply with, quote, any, that's why I circled it, any executive order issued during the COVID disaster is an offense punishable by a fine not to exceed $1,000 or not to exceed 180 days. That's what the governor said. He said the Texas Disaster Act gave him the authority to punish you and me if we don't do what he says. Okay? We're going to find out in a minute how wrong he is. Second, he said, there's another place in the Texas Disaster Act said the governor may issue executive orders having the force and effect of law. Now that's a very curious turn of phrase. Have the effect of law. I guess it has to have the effect of law because what? It's not law, right? Okay? And that's a kind of a tricky trick, it seems to me. If you're going to act like it's law and do everything as if it's law, it sounds like it might be you're trying to make it a law through trickery. That's what it sounds like to me. And that's what, of course, they're talking about with force and effect of law. Okay? So let's go on to the next slide. Okay. So let's go and see where, in another part of the Texas Disaster Act, where it talks about what you can do with penalties under the Texas Disaster Act. It said, well, first off, you're supposed to create an emergency plan. That's what the governor's supposed to do, what county judge is supposed to do, mayor's supposed to do, regional authorities can do it. Okay, and of course, the Texas Disaster Act was designed for hurricanes and tornadoes, maybe wildfires. They had one little word in there about epidemics or pandemics. I can't remember what the word was. But clearly, most of the structure of the Texas Disaster Act is all about hurricanes. That's what they were thinking when they were talking about it. And these guys have taken, it's like a nose of a camel underneath the tent. I mean, they took just a little bit of words and then they started exploiting it big time. But anyway, so what does it say? A state's supposed to have an emergency management plan, okay? And then under the plan, you can set up offenses. Said the plan may prescribe a punishment for the offense, but may not be any bigger than $1,000 or $180. Okay, so I said, okay, it has to be in the plan, right? So I went to the website looking for the Texas Department of Emergency Management, and I found their plan. Guess what? It doesn't have any definition of crimes or punishments in it, right? So the governor is saying that the Texas Disaster Act gives him the authority to do it, but he hadn't even done what the Texas Disaster Act says he has to do to be able to do to punish us. There's another, okay, so yeah, I talked about that. Okay, here's where I want to get to. The other thing I learned at law school, the wonderful thing that Regazo said, this is what the governor's doing. He's just making it up. Making it up. And he changes it all the time. It's ridiculous. I mean, when you think about the Texas miracle, right? What is the Texas miracle that makes the wonderful job economy go? It is rule of law, freedom for people to do, entrepreneurs to do what they want to do, and the rule of law that creates predictability. An entrepreneur or a businessman is not going to go out and hire people when they have no clue what the rules and the law is going to be next week. And it literally, the governor's changing this almost every week, right? It's not just that he's issuing executive orders, it's that he's changing them all the time. You can't predict as a businessman. The governor touted the Texas miracle, and he killed it through his executive orders. So, okay, so that's pretty much that. All right, I want to talk a little bit more about separation of powers and how courts treat it. In the original founding days, after the founding, when we first started doing things, and the courts started trying to apply the Constitution to real-world events, they came up with a thing called the non-delegation doctrine. And the non-delegation doctrine is the idea if the Constitution assigns a power to a particular branch of government, they don't have the authority under the Constitution to go delegate it to anybody else. Okay? So, I mean, pretty simple stuff. Pay attention to what the words are. Pay attention to the design that the framers had. Why don't we do that? So that's the way we went for about over 100 years. We got into the progressive era. The progressives started wanting to the regulatory state. And they started at the turn of the 1900s. Then it got worse and worse. It got into the 1930s and the New Deal. And of course, the New Deal just created an incredible edifice of the administrative state. All sorts of regulatory agencies. If you think about what a regulatory agency does, it is part of the executive branch, but it's creating rules. It's essentially legislating within the executive branch. So, because the progressives knew that they knew better how to run your life than we did, they said, we got to get rid of this old fuddy-duddy notion of the non-delegation doctrine. And they pounded on the Supreme Court over and over and over again. The Supreme Court had been applying the non-delegation doctrine and knocking down all sorts of regulatory agencies. But finally, in the New Deal, they broke through, and the progressives captured the United States judiciary and said, yeah, okay, you can have your regulatory agencies. You can legislate within the executive branch. But one of the things they did along the way is when they started that process, there was all sorts of abuses of people's liberty that were coming out of the regulatory agencies, and so lots of violations of due process. So they created a thing at the national level called the Administrative Procedures Act, and what it did was it put a process around the creation of regulations. You had to have comment. You had to have a deliberation. If you violated the regulations, there was administrative courts, all sorts of due process around the regulatory stuff. So they created this kind of mini government within the federal bureaucracy. Texas has a Texas Administrative Procedure Act modeled along the same line. But I will tell you that the precedents in Texas law about gutting the non-delegation doctrine are not near as bad as what they are on the federal level. So the thing is, the standard now for Texas is, the president now, it says the delegation is allowed, quote, if reasonable standards to guide the agency in exercising those powers are part of the legislation. And of course, what the government lawyers are going to argue, when somebody goes in and says what the governor's doing is not constitutional because it violates separation of powers, the government lawyers are coming back and saying, the president is, if it's reasonable standards to guide the agency in exercising those powers, then it's okay. But and they claim that the Texas Disaster Act is a reasonable restrictions on what the governor can do. Well, I can tell you that you look at what's going on, it is not reasonable. The man is not engaging in reasonable behavior. And of course, he's busting through all the guidelines like we just said. He's supposed to do it through a plan, and he's not doing that. So there's all sorts of reasons why, even with the loosey-goosey judicial standards that we have now on the non-delegation doctrine, the governor is clearly violating separation of powers, Article 2, Section 1. Okay, so that's the case for why he's violating separation of powers. And of course, let's just talk about county judges since we're in a county that has a Comandante Hidalgo, okay? The powers delegated to county judges during emergencies are even less under the Texas Disaster Act than what they are to the governor. What can they do? They can stop ingress and egress out of a county. Of course, that makes sense during a hurricane when power lines are down and nobody doing that is designed to stop looting. And you can also order an evacuation. That's all you can do under the Texas. Judge Hidalgo can do under the county. Under the Texas Disaster Act. And yet, she thinks she can go and tell businesses what to do with masks, et cetera, okay? So she's violating the separation of powers as well. And of course, the mayor, likewise. Okay, now, next I'm going to go on to due course of law. The Texas Constitution calls it due course of law, Article 1, Section 19. In the federal Constitution, it's called due process. But it's the same idea. Before you can take, I think it's a pretty clear statement. It says, no citizen of this state shall be deprived of life, liberty, property, or privileges or immunities, or in any manner disenfranchised except by course of law of the land. Okay, now, but there's a whole bunch that goes behind this due course of law and due process. This is what lawyers live to debate about it in front of Supreme Courts. But I want to say that there's a fundamental principle of due process that is codified in the Texas criminal procedures. Every American knows this. It's the idea that you are innocent until proven guilty, right? Fundamental part of the American society. We do not presume you are guilty And we certainly don't presume you're guilty and not even give you a chance to prove that you're innocent. I mean, you shouldn't have to prove that you're innocent. They have to prove you're guilty. But if they're going to presume you're guilty, shouldn't you have a chance to say, hey, I didn't do it? Well, okay. So let's talk about the logic of both lockdowns and mask mandates. Everyone is presumed guilty of being a threat to others without even a chance of proving innocence. Okay? People said, Tom, because of this asymptomatic transfer stuff we got, you could be walking around and killing grandma without even knowing it. And I said, well, number one, okay, let's just accept that maybe as a scientific fact. I'm not sure it is. I've seen some studies that say that asymptomatic transfer is very rare. In fact, they tell me the reason I have to wear a mask is because if I cough or sneeze, it'll transmit a disease over to somebody. But I thought coughing and sneezing were symptoms. I thought they were talking about asymptomatic transfer, right? So anyway, the idea is behind lockdowns is because there's a low probability that you might hurt somebody, you are prohibited from living life. Because there is a low probability that you might be sick and you might do something, you have to wear a mask. That's the logic of that. Okay, now, and they tell me, they said, Tom, it's just like driving while intoxicated. Intoxicated people are a danger to other people. We need to respond to that. I said, I agree with the logic behind driving while intoxicated, okay? Driving while intoxicated, though, does not, see, here's the deal. You got to get to what the harm that you're trying to stop with your law, right? Even the title of driving while intoxicated tells you what they're trying to do. They say you shouldn't drive if you're intoxicated, okay? And what do they have to do to prove that you're guilty of driving while intoxicated? They have to prove that you're engaging in the threat. They have to prove that you're intoxicated and that you're driving, right? Okay? They don't presume that you're intoxicated just because you're driving. That's what lockdowns are. Lockdowns presume that because you're living, you are guilty, right? They don't say, if they're going to make a law that's like driving while intoxicated, it ought to be earning a living while contagious, okay? And then they would have to prove that you're contagious, right? I can't think of anything worse than just to say, because you exist, you're guilty. We get to control you. That's what lockdowns are. That's what lockdowns are. And that's what mask mandates are. The same thing. Maybe if we wanted to have something like driving while intoxicated, it would be MWC, maskless while contagious. And then we would have to prove that you're contagious and not wearing a mask. That's what it would be. But the lockdowns and the mask mandates are a violation of due process. That's the basic idea there. Okay, I've kind of talked about this. Presumption of guilt. Okay, next topic, natural rights. If you read anything that the framers wrote and understand what they were trying to do when they wrote both the United States Constitution and the Texas Constitution, their goal was liberty. In fact, you start off right off the bat with the ultimate foundational document, our Declaration of Independence. Why did we do what we did with the Declaration? To secure these rights, natural rights that each individual has. And that's why governments are instituted. That's why our constitutions were implemented, to secure our natural individual rights. And if you're trying to interpret the Constitution and get it right and trying to do it the way the framers intended it, that's the lens you got to interpret your Constitution through. Okay. The Texas Declaration of Independence started it this way. When a government has ceased to protect the lives, liberty, and property of the people, from who its legitimate powers are derived, and for the advancement of whose happiness it was instituted. In other words, they kind of did it negatively. They were in a negative mode. They were thinking about a dictator coming down on them with a big army when they wrote this. Okay, Texas Bill of Rights preamble. That the general, great, and essential principles of liberty and free government be recognized and established. Sounds like it's a liberty-oriented document to me. Okay, I got a challenge for you. Go online to the Texas Texas Constitution. It's a pretty easy thing to do, and they have search capability. Go search for the word public health. Search for the word health and safety. Search for the word police power. Search for the word common good. Search for the word even general welfare, which was talked about in the United States Constitution. I challenge you to do it. If you do, and the way I did, none of those terms are listed as a goal of the government of Texas. Let me just keep on going. Okay. And in fact, we have former Texas Supreme Court Justice Don Willett in 2015 in a case said, the Texas Constitution then and today exists to secure liberty, right? Then we have the Texas Bill of Rights, Article 1, Section 29. Wonderful, a wonderful thing. I got to read this. It's so wonderful, okay? The Bill of Rights accepted from powers of government and inviolate. To guard against transgressions of the high powers herein delegated, we declare that everything in the Bill of Rights is accepted out of the general powers of government and shall forever remain inviolate. And all laws contrary thereto are to the following provisions shall be void. Can you say it any more directly than that? Okay, and let's also talk about a Republican form of government. What is the difference between a Republican form of government and a democracy? I think this is very important, and sometimes when you read the framers, it's kind of hard to get it, but I think I've landed on it. A Republican form of government's goal is to secure the individual natural rights of each citizen, okay? A democracy elevates a process of government to a goal. And when it does, it embraces the highest principle to be that a majority can violate the rights of a minority. We are a republic. That's what Benjamin Franklin said. We're a republic, not a democracy. And now, a Republican government does use democracy, the process, to select leaders. But it also, our Constitution puts all sorts of structural and procedural supermajority requirements in place to secure individual rights. Democracy is not an end-all and be-all. That's rule of the mob. Republics exist to protect the ultimate minority, the individual, from the tyranny of the majority. And that's the way, that's what the Constitution tells us we should be doing with our Bill of Rights. That's the way we should, judges, when they judge it, or we as individuals, when we're thinking about constitutional meaning, should approach our foundational documents, the Constitutions of Texas and the United States. Okay. Now, if any of you follow me in Texas constitutional enforcement, you know I'm not a big fan of the United States Supreme Court. I know that the United States Supreme Court is not the final arbiter of constitutional meaning. I think it's fantastic if they do declare constitutional meaning because, you know, they swore an oath to honor and protect, defend, and the Constitution. So, but a lot of times they get it wrong, and I don't think, and I know that the federal government doesn't make the United States Supreme Court the ultimate arbiters of constitutional meaning, but I do believe a judicial function, both at the federal and the state level, that is very vital to honoring their oath of those judges is to use judicial review to knock down illegitimate, unconstitutional acts of the other branches of government. And in Texas, see, the thing is, I set up the Texas constitutional enforcement as having the state of Texas and our individual, our governor, our legislators, our county judges, our mayors, our sheriffs, etc., to exercise independent judgment of constitutional meaning and stop the feds when they try to violate it here in Texas. And to a certain degree, we can do that when we're trying to go up against the state of Texas. One of the things that's been effectively happened so far is there's been county attorneys in here in Texas. There's been county sheriffs here in Texas that said, I'm not enforcing these stupid mandates that are not law on my citizens, right? There's a lot of them that have gone along. But if the local level people where the rubber meets the road actually take action to stop and resist what the governor's been doing, or the sheriff resist what the county judges have been doing, there's ways to stop this unconstitutional stuff. So I'm not going to go away from that. But I'm in this talk, and I still have hope. And there's evidences that the Texas Supreme Court is, when they finally get around to it, which is one of the things that's really irritating me, they're taking forever. They've turned down all the direct appeals to them, the mandamuses that go straight up. And they've said, nah, we like what you're doing. We really think what's going on. They give us all sorts of hints that they think what's going on is wrong, and that when it finally gets there, they're going to do something. But they said this is not the right procedure to do it at that moment. Bubble it up through the district court, the appellate court, and then get to us. And that's what's taken so long. But anyway, judicial review is an important thing. The other thing I want to talk about briefly is this. There is a war. I consider the progressive. See, the progressives hated judicial review. When in the early days when the judiciary was exercising the non-delegation doctrine and lots of other doctrines, they were striking down unconstitutional laws pretty often, especially the progressive legislation that were coming around at the end of the 1800s, early 1900s. And so when the progressives were thinking strategically, they said, we've got to undercut this judicial review stuff. We've got to take out the judiciary because they're a vital part of protecting the liberties of America. And they essentially have accomplished it. One of the ways they accomplish it is they call this thing, in courts, especially in the federal courts, they have this thing called standards of review. And they just make up these standards of review it makes them sound judicial, right? Okay, well, this kind of violation of a right is protected and it requires strict scrutiny, but this kind of protection of a right, like economic liberties, no big deal. We'll have a much lower standard review, which essentially you can never win against a statute on it. They call that a rational basis test. And the federal government did it, and for a long time, Texas judiciary has followed along what the federal government has done in those standards of review. But as of late, in 2015, they started walking back some of that progressive stuff on standards of review and making more things saying they ought to take more seriously constitutional challenges. And in fact, I see that as a big war, a philosophical war that's going on within conservative judicial circles. Essentially, I believe that the Nathan Hecht, our Chief Justice, believes in limiting how much judicial review of happens, because he considers judicial review striking down unconstitutional things to be legislating from the bench, right? I think he's wrong. I think it's his oath of office requires him to take a skeptical view of what's going on, to aggressively strike down laws that violate the Bill of Rights and not bend over backwards and find tricky tricks to try to let the legislature or the executive do unconstitutional things. And that's part of the war that's going on within the judiciary, the remnants of the progressive teaching. I mean, in law school, they started from the very beginning teaching you all this stuff. It's a progressive brainwashing thing. And even conservative justices coming out of the judiciary, out of the law school process, are challenged by some of these progressive notions that have gotten deeply embedded into the precedents and the culture of the law. So challenging some of this stuff on a natural rights basis is difficult. That's what I wanted to talk about. Okay, and I talked about standards of review. Okay, but see, I think the way you ought to judge the lockdown law, for instance, is let me come a little bit more into the history of it. The progressives also came up with this idea of the police power or public health as trumping liberty. all of the balancing tests they do in their standards review, they balance the liberty or the harm that's being done, the liberty that's being taken or the harm that's being done. They balance it against a legitimate governmental interest, like protecting public health or the police power or something like that. And I agree that things need to be balanced, but what needs to be balanced is all done in the context of liberty, of protecting people's individual rights. There's a legitimate notion behind the controls that these guys are trying to do during an epidemic, okay? If people walk around that knowing they're contagious and walk around exposing other people to a deadly disease, I think those people are violating the rights of others, right? So if you're going to be talking about this stuff, you ought to be talking about not in terms of public health versus liberty. You ought to be talking about protecting the individual rights by stopping people who are violating the rights of other people. And that's what Thomas Jefferson said with this quote. Rightful liberty is unobstructed action according to our will within limits drawn around us by the equal rights of others. That's what judges should be balancing, is whose rights are being violated and whose are not. Who's doing the violating, who's being violated, right? That's what we should be doing, and that's the balancing test. And my amicus in the Shelley Luther case was making the case that keep on moving away from the progressive standards of review. Take your standards of review into trying to figure out who's violating whose rights. Okay, so I think I've pretty much talked about all this stuff here off the fly. Okay, here's one other thing. Legitimate governmental interest. That's one of the balancing tests that Texas has right now. I want to know, is flattening the curve, if you think about it from a liberty perspective, is flattening the curve to stop overrunning the healthcare system a legitimate governmental interest? One way of saying it is, whose rights are being violated? Is it the right of a patient being violated by having the system being overrun? Is the healthcare system's rights being violated by having more customers than they can handle? Is that a violation of their rights? There are no violations of anybody's individual rights by having a lot of people show up at the healthcare system wanting service. And I guarantee you, here's one other thing that's just bugged me to no end about what the governor has done. You know, in Obamacare we said you shouldn't get between the patient and their doctor, right? Okay? What did the governor do during this deal? He declared what a healthcare institution should do. He said, you got to turn away, quote, elective surgery or elective deal and keep it open, keep it empty and open, waiting for this expected COVID surge. As a result, you know, some of these elective surgeries weren't that elective. I'm waiting yet to see. I want somebody to do a study. How many people died waiting on their elective surgery while COVID, the hospital stayed open for the the expected but not realized COVID surge, right? Command and control from a centralized dictator does not produce good results, right? Who better can triage people in a medical emergency? A trained person who has experience, who's sitting there looking at all the cases in front of them, can make that intuitive judgment that they need based on their experience and their knowledge and their learning, and decide who gets, if there's limited resources, who needs it the most. Is it the doctor and the health system, or is it Governor Abbott, right? I mean, he just went full bore dictator commie on us, and people have died as a result. Yeah. Huh? Okay. All right. So my bottom line is public health are not magic words to gut rights, right? And the Texas Supreme Court gave us this hint when they turned away one of these mandamuses saying, come back later. They gave us a strong hint about what they were thinking. The Constitution is not suspended when the government declares a state of emergency. And so I'm just waiting. Please, please, please get here. Okay. Now, what can government legitimately do? Texas has a a wonderful statute. I don't know if it's wonderful, but they have a statute that they created in the 80s after the HIV epidemic called the Communicable Disease Statute. And essentially what they say is contagious people shouldn't be walking around infecting other people, which I agree with. That's a good thing. Okay, and so they have a thing, they define isolation and they define quarantine. Isolation is when we know, we've tested, we know that you're sick, and we tell you to stay home. Quarantine is when you've been exposed to somebody we know is sick, or maybe you're from outside the state and we know that you've been exposed or likely to have been exposed in a high probability area. And we're going to isolate you for a period of time, 2 weeks, until we're sure that you're not sick. I think those are legitimate powers of government to protect each one of our individual rights. But what is tyranny is what we talked about before. Government limits the normal actions of apparently healthy people that might be contagious. That's the difference. So what the governor should have been done, he used the wrong statute. He used the Texas Emergency Act. He should have been using the Communicable Disease Statute. Okay, so there's enough of that. Okay, finally, the last deal is equal protection. Pretty simple thing. This is a lot of what I think motivated Shelley Luther. She started seeing, she had shut down her beauty salon because the governor said they ought to, and she thought, okay, well, we'll do our part. Well, it got to be a month, and they'd said, well, we need 15 days of flattening the curve, and it was a month, and they had already opened up and allowed a whole bunch of other people to start doing business, and she was going, we can be as safe as what they are, whether they're safe or not, that's the question, but we could be as safe. Why does the governor get to pick and choose? This is not equal protection. The very concept of declaring somebody essential or non-essential, it violates equal protection. That's the argument behind that. There's not much more that needs to be said there. Okay, and finally, I'll just say, lockdowns are a weapon of mass restriction and destruction. They don't have anything to do with a free society. And then I want to talk, finally, a quote, just a beautiful quote that describes Governor Abbott better than anything I've come across. Of all tyrannies, a tyranny sincerely executed for the good of its victims may be the most oppressive. It would be better to live under robber barons than under omnipotent moral busybodies. The robber baron's cruelty may sometimes sleep. His cupidity may at some point be satiated. But those who torment us for our own good will torment us without end, for they do so with the approval of their own consciences. See, the goodness of our governor, the skill, the incredible abilities and energy of our governor has been turned to the dark side because he thinks he's doing it for our own good. He's bought hook, line, and sinker the progressive notion that it is the government's job to take care of us and be our daddies and our nannies, not to be the protector of our liberties. So, right. Okay. All right. Now I will move on to contact tracing. Contact tracing is part of this idea of isolation and quarantine. In the early days of an outbreak of a serious illness, it makes sense to go figure out, okay, this person had a serious disease. Who have they come in contact infected? Maybe we can get this thing under control. But it is designed for the early outbreak stages of it. What this governor did is, without budgetary authority, he just went and signed a $250 million deal, like 2 months after the virus was known to be loose. I mean, a lot of people think it was loose long before, and did it. I'm okay with contact tracing in the abstract. I'm not okay with it in terms of using like NSA, violation of Fourth Amendment search and seizure, not doing it without a warrant type stuff. That's one of the dangers of contact tracing. But to do it this way, this is the horse is out of the barn door the way the governor did it. And of course, when you do it way late, it's way expensive. It's just a big time waste of money. And it's more destructive. Think about it. I'm so happy that they have not been implementing contact tracing the way they were envisioning doing it. Because if they had, everybody who got a test, then they would be shut down for 2 weeks and their family would be shut down for 2 weeks, and you never could predict anything. You couldn't do any kind of business because your quote essential workers would be isolated and couldn't work. So I think contact tracing, had it been implemented the way the governor wanted to, would have hurt us and harmed our economy and harmed our liberty more than the lockdowns. It has its place, but boy did he mess it up. Okay. Okay, that's enough. Okay, and here's the thing that I think is coming at us, is mandatory vaccinations. By the way, there's two other major topics I left off these slides. Where are we sitting on time?
We're about 1:15 now.
Okay, so I need to be stopped pretty soon. Mandatory vaccinations. Here's the deal. I think mandatory vaccination is a fundamental violation of natural rights, right? Okay. I mean, you know, what's really amazing about the pro-choice people on abortion say, my body, my choice. I mean, okay, well, why don't you apply that principle consistently? You know, I don't buy it in the abortion deal, but you know, it certainly makes sense in the mandatory vaccination deal. Okay. The one thing I want to say is the precedents are bad in the judiciary. The Facebook lawyers love, you know, the guys that want to love to quote this little case called Jacobson v. Massachusetts. And Texas Supreme Court has one called Itz v. Pinnock. Jacobson v. Massachusetts was a mandatory vaccination law in Massachusetts that allowed rich people to buy their way out. Okay, and one guy tried to challenge it. He challenged it in Massachusetts. The Massachusetts Supreme Court in the progressive era turned him down. The United States Supreme Court, this is before they were applying the incorporation doctrine through the 14th Amendment, essentially said, that's a Massachusetts law, don't be bothering us. And besides, Massachusetts has a word in there about common good. We're going to let the Massachusetts deal. Well, the progressive thinks this is a wonderful precedent that says anytime any government anywhere wants to force you to take a vaccination, they can. I think they're wrong. Texas Constitution is a lot stronger than the Massachusetts Constitution. Today, it's stronger than the Massachusetts Constitution was then. The Texas Supreme Court in the 70s, when the Dems had pretty much flipped to being liberal from being conservative, and they'd captured the judiciary, did a very progressive, one of the worst written things ever, on whether or not school children could be forced to take vaccinations. And they said, yeah, no big deal. We're enlightened nowadays. It's a cool thing. No big deal. And so anybody who wants vaccination choice for children in schools now, we've had to win that legislatively. It's not been won through the courts. And fortunately, we have won it legislatively. But the thing is, to count on judicial review to win forced either by edict or by law mandatory vaccinations at any, whether it's federal level force or Texas level force, is not something I think we can count on. It's going to have to be one of two things. Our legislature in this next legislative session is going to have to do something about it to stop it with some sort of good legislation. I don't know if the governor would sign such, by the way, even if you got it out of there. The beautiful thing about a Bill of Rights edition is even though it takes 2/3, and that means we have to get Dems to be on their side, but you would think that they might be, although the reality is they are pretty hardcore control your life type of people. But if we can get 2/3 of both legislature, we can put in front of the people an addition to the Texas Bill of Rights that makes it explicit, an explicit codification that it's a natural right not to be forced to take a vaccination or have other medical procedures forced on you. And the Republican Party platform has an additional call for that this time around. So I think that's the best political way we can do it. Of course, the other way that's going to have, if they do it and we don't get the legislator or their Bill of Rights thing and the judiciary fails us, which it's likely to do on the mandatory, it's going to have to be mass resistance. It's another, there's so many flashpoints for a coming civil war, but mandatory vaccinations could be one of them. So that's that. Okay, now I guess I'll stop for questions. There's two other major issues I've forgotten to talk about, but go ahead.
Okay, this might be for another topic,
You-
but this is great. Translate it to the private sector because they're using the private sector to force these things on us: vaccinations, testing, masks.
Yes, thank you very much. That is exactly the other topic that I want to talk about. Since I put these slides together, what has happened is, these guys are trying to figure out how to run our lives, and they're going to use every trick in the book, and they hit upon a winning scenario. And it was the county judges, the progressive county judges in San Antonio and Lena Hidalgo here in Harris County that figured out the idea and talked the governor into letting them do it, okay? And that is, we'll just put mandates on business who will do the dirty work of doing the enforcement. Hey, Governor, you got embarrassed by trying to enforce it on Shelley Luther and you backed off. Hey, you don't have to be the heavy. We can make business the heavy, okay? Now, when you think about, the term fascist is thrown about in a lot of different incorrect ways, right? But when you look at what Mussolini did in his fascist party there's a whole bunch of elements to what fascism is. But one of the essential elements of fascism is you maintain the structure and the look and feel of capitalism. But you have regulations of business so that you get control of everybody through business. So my opinion is what is being implemented here by primarily the county executives with the governor's implicit approval is fascism, okay? Now, the thing is, they use my principles against me. I believe that a business owner should be free to set the conditions upon which they want to do business with me, okay? And so, in the early days of my mask resistance, which I've been engaging in, I was kind of like, okay, well, they're doing it. But then I realized, okay, wait a second. They're the one, it's the small business people, and I'll talk about the big business people in a minute. It's the small business people that are being put in the box. They're being told, we're going to fine you, and they're scared of that. I mean, they don't have lawyers, and they don't know that it's, that if they take it to court, they'll probably win. They just want to earn a living. And they've already been hammered by the lockdown where they've already been shut down, right? And so the big bad government threatens them, and that's enough to put a whole bunch of them in line. And then in the government, even though they put these words in the thing, oh, you're not supposed to be an enforcer. Well, they really are expecting them to do that. I mean, one of the things I've been thinking about asking, and so far nobody's done it, but if some low-level employee challenges me when I'm walking around in a business without a mask, I'm going to say, did they give you a raise? Did they pay you to be a cop too, in addition to the other stuff? They're already making you wear that stupid mask. How are you getting paid enough to do this? I mean, that's the rock in the hard place they put them. And what I've decided is, when they are under the force of law to essentially be a trustee in the prison, the fascist prison these guys are building, I'm not going to use my principles of respect for private property to do that. I'm going to respectfully go, look, the bad guy, I'm not the bad guy. The bad guy is the guy that's threatening you. I'll help you out if you get in trouble. But I want to give you money if you'll respect my freedom. And so let's do a deal here. And so far, I have found very few places that will stop me from walking around without a mask in the places they do. My bank, amazingly, what's interesting is they put an exception for banks, but I went into my bank, Wood Forest, and they wanted me to wear a mask walking into a bank. It just blew my mind. But so anyway, I think the fascist has, and the same thing is going to happen with the vaccination stuff, right? Especially if you work for the big corporation, or if they try to make it where just to go into a grocery store you have to prove you've got a this is burn it down time. Are you talking about burn it down? This is a point, but that's a fascist point we're not going to go beyond. It's just not. And I don't know exactly how we fight it. It starts with trying to get something through the Texas Bill of Rights that makes it very clear that you can't force people to do that. The thing is, You can write it in the Texas Bill of Rights, and they'll still think, well, we can do it through government, we can do it through business. And so I think we've got to craft the language right, so you can't force business, government can't force it. There's one other aspect to this fascist thing. One of the things that you need to know, the governor, he created this coronavirus task force of businessmen, big businessmen in Texas, okay? One of them, I thought, when all this mass stuff started, that okay, great, okay. If I have to drive out to Brookshire Brothers in one of these small towns instead of going to HEB, because I know Butts is a buddy of the governor and he's going to do whatever the governor wants him to do because he loves controlling us too. And Kroger was wonderful in the early days, although they went in line after everybody else. But Brookshire was one of the guys the governor put on his task force. Right? So in all these small towns all over Texas, they've had the mask mandates at Brookshire Brothers. Even though there was no mandate on it, it was just being cozy buddy-buddy with the governor, but with the big dog that did it. And that's an insidious way of taking away people's liberty, to take the businessmen and try to make them our keepers. And we got to figure out how to fight it and resist it in any way we can. So I'm sorry it took a long time. We got a lot of questions. Go ahead.
How do you think, this might be going ahead a little forward, but Civil War, how do you think that comes about, and what does it look like in this state?
I think it looks more like South Carolina in the American Revolution. It's neighbor against neighbor, house against house. It's low grade, individual against individual stuff. I mean, to the degree that in Texas it could be rural versus urban, but in Harris County it's got to be, house against house. I mean, it's a terrible thing. It's a terrible thing. Somebody asked me, "Are we about to be in civil war?" I said, I think, I realized this on 9/11. 9/11, when they hit the towers, they had already tried for the towers first time. They had attacked the USS Cole in Yemen, and they had bombed the United States Embassy in Nairobi. And I'm sure Al-Qaeda was going, what's a terrorist got to do to get some respect for attention from Americans around here? Well, they finally got it when they went big and spectacular with the World Trade Center. They had declared war on us long before most Americans even knew they existed. Right? Okay? The same thing's happening right now. The communists have been, if there's any organization that knows this, it's John Birch Society. The communists have been working for decades to try to take over this country. And now they are getting to what they consider to be the end game. They have declared civil war on us. The only question is, when are we going to realize that we're in a war and that we're under attack? So yeah, but it's in the smaller counties where you have sheriffs and a local infrastructure that's going to do it. You use whatever governmental officials you have to fight back. I mean, Texas has a wonderful statute. The federal government has a statute. I heard the Attorney General Barr say he was going to he's urging U.S. attorneys to start using the sedition statute. It is a crime in the United States, and it is a crime in the state of Texas to try to undermine and subvert and destroy the constitutions of the United States and of Texas. And yet, that's what these guys are doing. That's what BLM and that's what Antifa are doing. Our Constitution and our way of life and your liberty, whether you and your children go to a concentration camp, to an American gulag, is at stake. That's what's going on right now. Yes, ma'am.
I saw that last night on Fox, and I'm glad to see you're up to date. But Judge Napolitano, which is Fox's favorite lawyer, poo-pooed the sedition.
Well, okay, I mean, he's a liberty guy, and the deal is, laws against going up against the government have been used by tyrants for a long time. And in fact, if you look at the constitutional provision in the United States Constitution on treason, it makes it very clear that you got to be pretty straight on what it takes. Two witnesses, right, to say, and it has to be assisting the enemies of our country, right? But to do treason. Now, sedition is not mentioned in the Constitution, and to a certain degree, if you're a strict constructionist, kind of the way I am, I guess I could say that the federal law, any federal law besides the ones listed in the Constitution, are probably not legit. Certainly the ones against owning guns are not, because they're not authorized. But the thing is, if you take enumerated powers, there's only delegated enumerated powers to the federal government, and they list what crimes the federal government can do. Any more of them, the federal government doesn't have, right? And sedition is not listed in the United States Constitution, but the deal is Texas has such a law as well, and there's not those enumerated power issues there. And I believe somebody who is trying to destroy liberty, is trying to destroy the very way of life we have, is engaging in violence against the people of Texas, and that should be a crime. To try to destroy our Constitution and our way of life should be a crime. So I've been called a libertarian before. I don't mind being called one, and a lot of libertarians might say, oh, that's just too much power to the government. Well, in this situation, I just don't believe that a sedition law is a bad thing. Certainly at the state level, I can argue both sides at the federal level. Yes, sir.
Sir, what's your best guess on a time frame for a Texas Supreme Court hearing? Just a while ago.
It's going to be sometime in 2021 is my bet. Yeah, that's what I think. Yes, ma'am.
Yes, the American Association for the Advancement of Science recently published an article documenting the fact that all the top COVID-19 vaccines, including the two fast tracks for early completion, have been developed using the thymus, the livers, retinal, and other tissues from electively murdered aborted babies. This is serious. We're murdering in the most painful way, keeping them alive to later stages to get the best of what they want to do. That's first and foremost the worst thing that could happen. We're not protecting our precious unborn neighbors. And then the ramifications of the health to force these vaccines on the rest of the innocent people.
Right. For the video, I'm going to repeat your statement in question. And essentially it's that aborted babies are used in the manufacture of the vaccines, the COVID vaccines. I haven't heard that or know that, but I don't doubt it or challenge it. And that there are I think the other thing that I got from you is that there are dangers of efficacy and dangers of actually things going wrong with the use of these vaccines. And so, I can guarantee you my family's not taking it. And in fact, we'll die to stopping from taking it if we have to. But, yeah.
Trump has been our most pro-life president. He may not know this, so we need to contact him and let him know.
Right. Yeah, it is. If we want to take a commentary on Trump's performance on all this, I am so happy that he essentially let most of this stuff do it at the state level. He's essentially a commitment to federalism, and I salute him for that. He's surrounded with the deep state, big pharma controlled guys who are feeding him all sorts of stuff. He's just trying to do the best he can, and his instincts are usually pretty good on deep state stuff, but I think he's probably been snookered a bit on that. And I agree with you that letters to him about this probably wouldn't hurt. Yes, go ahead.
One aspect you didn't mention that I think is very important. There's a precedent that is being set by all this in terms of if this governor and other governors get away with this, in other words, if the courts or legislature did not ban this, what's to stop the next governor from declaring an emergency on account of global warming? You know, the Earth's going to burn up in 10 years.
Exactly.
So they can declare and regulate how much gasoline you buy, how much food you buy, anything, because it's all related to the global warming.
I agree. What you're saying is, for the video again, what you're saying, you've already got it, so I don't, all right, but no, you do need it. Okay, good. Is that there's a precedent being set here for even worse tyranny to come if we don't, in this next legislative session or through the ballot box in 2022 or through judiciary, somehow give a message that this is never to be tolerated again. And I agree wholeheartedly with that. I'll say I've seen several indicators. We've had 2 indicators so far that at least the conservatives in Texas are not very happy with their governor. Okay. The first was the platform debates at the Republican Party convention. 4 planks came out of that debate, which were direct rebukes of what the governor was doing during the COVID stuff. Okay. Second thing that happened was, I think the chair race, you can say what you want about others and other factors going on in it, but for me, and I didn't take a position in that chair race, but it's very clear to me that Alan West was out there on the forefront of criticizing the governor's COVID edicts, okay? And James Dickey was trying to straddle the fence, and clearly in the view of the rank and file of the people who went to the Republican Party State Convention, was too buddy-buddy and too timid in terms of not addressing what was going on with the governor. And I think that's why James Dickey lost and why Alan West won. So that's the second indicator. We're having a third indicator right now going on, and that's where I just came from and I'm about to go back to. And this is this special election that the governor called right in the middle of when he told us we were supposed to be working to get our house, to keep the Texas House red, right? He created essentially a primary. It's a special election in Senate District 30 in North Texas to replace a state senator up there who's gone to be a congressman. And he's endorsed a sitting state rep and accelerated it on the assumption that his name ID and his resources and his war chest, and the governor is putting hundreds of thousands of dollars into the race personally. Okay, his campaign money is, but what's happened is Shelley Luther jumped into the race and is the grassroots champion. Okay, and with her name ID, so this is going to be another a way to tell what the people of Texas think about the governor, and it's very important from in that perspective. And I think it's a precursor of the 2022 primary for governor, whether the governor runs again or not. I think it's increasingly likely that he will read the polls and figure out that maybe he shouldn't. But I guarantee you, if he does, he's going to have a whole bunch of committed, fired up people and a decent challenger to him in that primary. So anyway, I got off the topic a little bit, but precedents are important. The framers knew it was. They started the American Revolution over, and they resisted a whole bunch of things that were smaller than what we're enduring because of the precedent-setting nature of it. This cannot stand. It cannot stand. Yeah, okay, yes. We're out of time? Okay, we're out of time. All right, thank you.